Welcome to the Challa Law weekly webinar. Let's wait a few minutes as we do every week for people to join. This will be the last webinar for this year as we all break for the holidays. And like I said, we're going to give it a few seconds for people to join, and then we can talk about some of the changes that are taking place. So like I said, let's give it a few more seconds. Good morning. We're just giving, I'm just giving people a few seconds to join. And then we can get started. So let's go ahead and get started with this week's weekly webinar. If people start joining, then they'll join after the webinar started. But I want to thank those people who keep signing up for our webinar every week. Thank you for joining us and supporting our efforts to provide key immigration information to you. And then for those who are joining new for the first time, welcome. We will resume these webinars in January, where there'll be a lot of really important things to talk about, such as some positive things like the new Biden agenda for immigration. And hopefully it'll be about opportunities and how to leverage those opportunities instead of restrictions and how to overcome them. So let's get started with today's webinar. First, please connect with us if you haven't already on our various mediums. We've got Facebook, Twitter, Instagram, YouTube channel with a chock full of menu of webinars that not only pertain to the recent changes, but pertain to a lot of things that may be critical to you, like when do you file an amendment? How do you respond to an RFE? You know, all these other, all the other type of information that you need at any point. And we go through step by step with tips and strategies. Join us on LinkedIn and on Instagram. And like I said, on Telegram, I'm sorry, where especially during the time that we're not having weekly webinars, all our updates will be, that's a great way where we can talk directly on the Telegram site. So as I stated, the webinars have a lot of really critical bits of information that can be helpful to you at any point. Please subscribe if you find them helpful, share it with your friends, and comment. Like I said, I love to hear from you. Before we go any further, please reserve your questions to the Q&A. Don't put them on chat. We will go over questions at the end of the meeting, but we will only entertain questions on the Q&A. So please use the Q&A to post your questions. So there's been a lot of buzz about the bill that has passed both the House and Senate that reduces the backlog for permanent residents. The House bill is 1044, the Senate bill is Bill 386. So what can we expect from this? What has been happening? And what's going to happen to the people who have already filed for permanent residence? If this bill gets enacted, how would that impact those that are already in the queue? Are some critical questions that we will answer today. So first of all, it's important to understand how the checks and balances system work in the United States. Checks and balances means that our founders thought that absolute power in any one branch of government was really, concerning. So they wanted to balance out the powers. So the executive branch, which is the president and all the agencies, federal agencies under that, under the presidency, really have executive powers, and they're pretty vast, but they are executive powers in terms of operating what is happening within the purviews of those various departments. And yes, there are certain restrictions on that, even on the powers of the president. You have the judicial branch, which is the courts. And then you have the legislative branch, where representatives of the people are supposed to be drafting legislation and enacting bills that serve their particular constituency. They're supposed to be our voice in government, basically. And, there are, like I said, restrictions for each. For example, Congress can enact a law, and you've seen this, whether it's been with the Affordable Care Act or other pieces of legislation where it's been challenged in the courts. And so it goes up and it has to go through an appellate process. That means it's got to go up through the chains. And if there is a case in controversy, and if the Supreme Court elects to review it, they can review it, and they can say that the legislation is constitutional or unconstitutional. So that's how the judicial branch checks on the legislative branch. The same thing with the president. They can, like presidential proclamations, the courts can decide that the presidential proclamations or that the agency actions are not correct. Either they don't abide by the APA or they find them unconstitutional. So the judicial branch has the ability to check on acts of the president. And, the president has the ability to, nominate judges and place them on the federal bench, which we've seen substantially done within this tenure. The president can veto legislation that's passed by the House and Senate. And then, as an additional check, if there's an overwhelming 3/4 majority within Congress, and the Congress can overcome a presidential veto. So there are various ways in which these branches check and cross-check each other. So, these are just various terms that may be helpful to understand how a bill becomes law. There was a song back in when I was growing up, I'm just a bill and I'm on Capitol Hill, and it would go through the progress of what it takes to get passed. And so, there is, issues called filibusters where senators try to delay or prevent a vote by delivering long and lengthy speeches. You can come up with a bill and present it to your legislator, but only the legislator can introduce the bill on the Senate floor, House or Senate floor. And then once they pass both the House and Senate, it gets referred to a committee to kind of hash out the differences between the House bill and the Senate bill. And during this time, there are a lot of amendments that can be added. That's why when you read a bill, sometimes it's absurd, and it's clear that the person who drafted it didn't understand how that particular government function works. And the reason is it's all this compromise. So what they do is, okay, we have a bill on appropriations or spending, and suddenly they'll tack on something that has absolutely nothing to do with that. But they know that they need this passed, and they think that this is a way in which they can get their kind of initiative signed into law. So there's always all these motivations for these various actions. And like I said, even if it gets through committee and then there's a vote, on the bill before Congress, It then has to go to the president's desk for signature. The president can sign it and it becomes law, or he can veto it. If he vetoes it, as I stated, if there's a 3/4 majority, they can override the presidential veto. So right now, even though the Senate passed 386 unanimously, it's been pending for a long time. 2019 is when the bill kind of started seeing movement. And there have been certain amendments that have been attached to the bill. The bill itself eliminates the 7% country cap for employment-based visas, trying to relieve the backlog. So no more than 85% can be allotted to any particular country. This is definitely going to provide an immediate relief. It won't provide a long-term relief, because eventually the backlogs will resume. What is great is, it gives greater protections to children who have been aged out. And for me, that's the biggest, in addition to the ridiculously long wait period, where effectively, H-1B employees are just shackled because, they're stuck in this very long immigration process. It really kills me that children age out and don't get to benefit from their parents' permanent residence process. So I think that is a critical addition to the bill. There's a new amendment now. If anyone has been keeping up on this, the HR 1044 House sponsor, Zoe Lofgren, who is a Democrat delegate from California, said, while I recognize yesterday the Senate passed the amended version of the Fairness for Highly Skilled Immigrants Act, while I recognize the sincerity of all members struggling to find solutions, unfortunately, the provisions sent to the House by the Senate are most likely going to make matters worse, not better. And it's because of the additional provisions that were sent in. And the Center for Policy Studies, Jessica Vaughn, said this would make significant changes to the employment-based green card system and moves us further away from a merit-based process. It rewards companies that replaced Americans with guest workers. Will the president sign it? So you hear a lot on both sides. The U.S. tech workers, talk about how issues related to the amended bill. And the Congressional Research Service had some findings after reviewing the bill, and they said that it would not alter the growth of future backlogs, which is what I said. And they talk about how the impact would be for, even though the 7% removal of 7% backlog would help India and China, their issue was that it would hurt other countries. But my stance on that is India and China have been waiting too long, and they have been penalized by the way our current system is for a very long time. So the mere fact that it's not going to be applied equally throughout does not take into consideration the fact that, people from India and China have, like I said, have been unduly punished for a long time, pursuant to the current system. So there are a lot of, like I said, there is the H-1B provision, so that people have only held the status in the past 2 years, would not be put in front of the line, basically. It also has a do no harm provision. This is what I was talking about for those people who are already in the process, so that, you know, the people who are already here don't get put in the back of the line from the people who are affected by this. Some other provisions is prohibiting companies from getting any new H-1Bs after the enactment. Exempts the renewal applications for those changing employers. It allows the USCIS to, you know, collect additional fees, which for the I-45J. The senators didn't agree to the age-out provisions to protect children for CSPA purposes. So there's a lot of things that clearly have been attached onto this. Some of them, you know, as an expense, you know, to the current immigration process. So these are the various, you know, issues that they see that would be impactful. And as I talked already about the Congressional Research Service, and remember the prevailing wage for perms and the restrictions on the H-1Bs. As we stated, the court struck those down, and because the agency didn't do it with notice and comment. We suspected as such. Both the wage increase and the new restrictions on H-1Bs was implemented without notice and comment. There are other things that are expected to be, you know, reviewed. Remember the presidential restrictions on entry. It expires at the end of this month, but it can be extended if they so choose. So we'll have to see if they think that since they're not going to be in power anymore, whether it's even worth extending it. But that'll be interesting to see how it moves forward. And of course, the DHS wage selection system for H-1B cap will be, that's not going to go forward. Because I think, you know, a lot of universities and rural hospitals and folks that we need just now would really be impacted by it. So these are some other things that you could expect to hear about within the next couple of weeks. Or people may just be riding this out until January 20th, where President Biden will take office and is expected to, through presidential, you know, executive order, address a lot of these immediately. It says, what do you want to see next week? I think we kept this from last week. This will be the last webinar until, you know, January. I think it's the first Wednesday in January where we will resume webinars. Oh, where is it? And then, like I said, if in the interim you want to learn more and make sure that you've got the latest, join us on our Challa chat forum, where we will still be we will still be updating folks on the latest changes that are taking place in immigration. And we'll also be updating all our various social media, you know, avenues where we can, you know, post about various changes, to connect with us on that as well. If you want to view the previous recordings, please check out our YouTube channel and to get some of that information. And I think it's now time if Chandrasekhar Challa will join us for our moderating our Q&A.
Hello, good afternoon, everybody. Yeah, I just posted the next webinar will be the first Wednesday, which is January 6th. So that's the date. So look forward to seeing you all then or hearing from you. So let's go ahead and start the questions. I'll pick the question that came up on the chat, but like I said, nice to have you put all your questions on the Q&A. So Tuba Kadwani is asking, hi, good morning. Wanted to ask about the updates on immigration policies regarding green card processing time.
Well, currently we're not seeing that receipt notices are coming in slowly. That has been the case for the past almost 1 year, where there's been a delay in processing time. I don't think that you're going to see an advancement in that until there's additional funding for the USCIS. Because remember, even though they didn't lay off their own workers, they did lay off contract workers. So I think they did that sometime in September. So that's really going to, that along with the additional new filings are really going to slow down processing. So that's what it is until the new administration. But if you join us for our, when we resume in January, we'll probably have greater updates as to, any thoughts on how funding would take place and other things.
All right. So let's go look at the Q&A marks. The first one, anonymous attendee, can I work on H-1B with employer A and in parallel work with employer B with my 485 EAD received from spouse's application?
Right. So anytime you work on an EAD with an employer other than your H-1B employer, you're in violation of your H-1B status. So your H-1B is no longer valid. So either you work on the EAD and work for whoever you want, or if you're going to work on your H-1B, you have to stick to working for the employer that you cannot work for any other employer but your H-1B employer.
Well, he followed up with, is it legally allowed from immigration perspective to work for two different employers at the same time, assuming the employers are okay working for another employer?
Yeah, but you'd have to do it on your EAD. So the minute you start working for another employer, you are in violation of your H-1B. So you'd have to make sure your current employer I-9s you with your EAD, and then the second employer also, uses your EAD.
All right. Next one is from Gugan Selamutu. I have filed for AOS. Once I get EAD and AP, can my wife use EAD without affecting the H-4 status, or does it have any impact on H-1?
Yeah, and that's really good that he asked that so we can contrast the two. The H-1B is an employment authorized status specifically for an employer. The H-4 is not dependent on working for a specific employer. It's the beneficiary or dependent of the H-1B. So the H-4 can work for anyone, work on the EAD pursuant to the AOS, work on the H-4 EAD. They can work in any capacity because it's not their employment that's tied to the immigration status or their employment that's tied to the adjustment of status benefit. They are just beneficiaries of it as dependents. So yes, your spouse who is on an H-4 can work for anyone.
Okay. Next question is from another anonymous attendee. I-140 has been approved with previous employer and had been with that employer for more than 2 years after the I-140 has been approved, before moving to a new employer. Previous employer has withdrawn the I-140 after more than 2 years of approval. Would previous employer be eligible to file 485 and I-140 concurrently?
They can file it concurrently, but they would have to file for a new I-140 because the other one was withdrawn, and they could file it concurrently. As long as there is a bona fide intent, as long as you have the present intent to work for the employer once the permanent residence is approved.
All right. Shafeen Tawheed is asking, primary applicant has correct priority date on I-485 receipt notice, but for derivative applicant, the priority date field is blank. Is this normal?
No, it was probably just, a mistake because your derivative, well, technically speaking, your derivative doesn't have a priority date because it doesn't vest with them. But they benefit from your priority date. So usually it's written in the derivative, but it's not anything to really worry about. You can call the USCIS and see if they can send you a corrected receipt notice.
All right. Sandeep Kancharla is asking, can a spouse utilize EAD and AP while husband continue on H-1B when the
Yes.
original 485 pending petition is based on husband's I-140 and priority date?
Yes.
Okay. Simple as that.
Yeah, like I said before, in that case, the H-4, because it's not the employment based work authorized status, it's just a dependent status. So the H-4 can effectively do anything they want because that is not the primary mechanism in which you've received your immigration status in the U.S.
All right, next one from an anonymous attendee. I filed Form 539 and applied for COS, cause to
Change of
B2
status.
visa on 6/22 after being laid off on H-1B. I'm still waiting to hear and not received any notification for biometric. Do I need to submit another application, and by when should I apply for an extension?
Okay, just make sure your application was received. You always want proof of that when you file, whether it's checking to see if they've cashed the checks, checking to see if the mechanism by which you filed, whether it's FedEx or UPS, whether you've got a delivery confirmation. And biometrics are delayed everywhere, so I'm not surprised. If you asked for, if your change of status was for a visitor visa, I don't think you mentioned that, and I would imagine, did he say visitor or a?
No.
Yeah. So if it's for a visitor visa, you would have only asked for 6 months. You then have to depart, even though if you filed for a visitor visa, change of status to a visitor visa, you'd have to depart prior to that a decision being made on that change of status because they're taking, the USCIS is taking greater than 6 months.
Okay. Next question, and actually just a comment. Thank you, Mr. and Mrs. Challa Garu, for all the knowledge you share and answer the questions. These sessions are helpful.
Good. Thank you.
AK is asking, any guess on the processing time for I-140 downgrade, EB2 to EB3?
No, I would say you can expect at least a 7 to 8 month, at a minimum, adjudication process.
Next one is from Kranti Viranki. I think that was her appreciation about helpful sessions. Her question is, I filed the downgrade EB2 to EB3 and the package was received by USCIS at Louisville, Texas on 10/21. Checks are not cashed and no receipt number yet. When contacted USCIS, they asked to send an email to lockbox service since they don't have any info in the system. And they email chat, I believe, or thing. Also say that the application might have been lost or misplaced. In such a case, what option do I have? Please advise.
Right. So we had somebody last week where, in fact, the lockbox folks, these are contractors, actually lost the application. And they tried to tell the individual, well, maybe you sent it empty. So what you want to do is you want to show proof that you filed. That requires two things: proof that there was a petition, and then refile. So what you would do is, if you use FedEx, UPS, whatever service you use, they weigh the contents of the package. And so that would show, what does that demonstrate? It shows that you didn't send an empty package. It shows that you sent something in the package. So that's one. Number two, you want to show proof of filing. So you have the confirmation that it was received on 10/21, and I would just resend them the file, a new filing with new filing fees, and let them know that since the other filing fees don't seem to have been cashed, have not been cashed, and they should have been cashed by now, that you're going to put a hold through your bank on those checks.
Okay. Oops. Anonymous attendee filed H-1B extension last week with new wages. DO reverted to old wages last week at the same time. How USCIS will review my extension petition? Consider the new or the old wages?
They would probably, if you filed it with the new wages, I would imagine that you've made some adjustment, either wage level or job title or otherwise. So, either it'll be adjudicated without an RFE, or there'll be an RFE in which you can justify that because the wage increase was all of a sudden and it was unlawful, the employers had to do what they could to address this sudden change which they did not have any notice.
All right, that's the guy who was asking about the B2 visa. I think B2, I guess that's the visitor visa. So he was just clarifying that that's what he wanted to, B2 is what, as I mentioned in my question. All right, I think you did say just that. The next one is from another anonymous attendee. I applied for I-140 for the first time and received RFE regarding the pay scale. I do have wage level 3 salary. Is it a cause of concern, or received RFE since I've applied in premium processing last month during many applications for downgrade are being applied?
Yeah, I don't know why you would have applied for, if you had been listening to our webinars, I've been saying, don't apply premium, apply regular processing. So if you've applied in premium and they're questioning the wage, I would have to see the RFE to really give you any clear guidance. I'd have to see what your previous H1, what the wage level and what the job title you chose, and then look at the RFE and see what it is they're raising an issue about. Now, one of the things, notwithstanding that, is that your lawyer can make an argument that, truly speaking, the wage increase was deemed unlawful by a federal district judge. And therefore, the USCIS should not be able to raise any questions with the way the employers and the H-1B communities had to address that. There are ways in which you can structure your response based on the fact that the federal judge found it unlawful, and make a justification as to why you chose the level that you did. This is very general, like I said, without me reviewing the actual petition and the actual RFE, but those are some immediate thoughts on how that can be addressed.
All right, Sandeep Kanchella is asking, can we do premium processing on I-140 downgrade once we get a receipt?
No, you don't. When you downgrade, either through an amendment or a new petition, remember, you don't have the original perm with you. When you do not have the original perm in the filing, you are not permitted to do premium processing because the USCIS has to request DOL for the perm, and that may take several weeks, if not months.
All right. Next is just a comment or a concern. Kugan Muttu is asking, I hope your daughter is feeling well. Really appreciate all the things you do for the community.
Yes, she is. Thank you for asking. And she is aggressively studying for her law school second-year exam. So she's doing well. Thank you.
Anonymous attendee is asking, previous employer filed for I-140 downgrade as amendment along with 485. What are the chances of approval if I don't join my previous employer, maybe for the next 6 months?
Right. Remember, it is the test is the present intent to join them once your permanent residence is approved. Now, I had stated earlier that I would not even entertain filing unless, because you made that, when you filed the I-485J, both you and the employer attested under penalty of perjury on a government document that you would do this. So it doesn't have to be, there's no time frame in which you have to join, but you do have to, have had the present intent to join. So if it's questioned, if you get an RFE, and if it's questioned regarding the bona fides of the offer, like, do you really intend to join? Have they really made a bona fide offer of employment to you? You have to be able to justify that. So joining them is one way. That's one way you can clearly demonstrate that your intent was valid. But there are other ways you can do that. Whether you have an employment agreement in place, whether you have emails that state, I will join by a certain date or a certain time frame or a certain event, as long as it is the present intent to join the employer at the time the permanent residence is approved.
All right. Question is, sorry, anonymous attendee. If I downgrade, will I lose original application if downgrade is rejected?
We have a webinar where we go through painstakingly amendment, filing a new petition, the impact of a denial on either. If you are amending, remember, first of all, that once you have an approved petition, the priority date vests with you for that petition, unless it was found that there was any fraud or misrepresentation, or it was erroneously approved to begin with. So that's number one. Number two is you can file a new petition in a variety of circumstances. You can file an amendment, and there are benefits to either. Now, if you file an amendment from an EB2 to an EB3 employment-based petition, and it is denied your request for EB3, your EB2 is still valid. So you can leverage that. If you filed a new petition for an EB3 petition and it's denied, your EB2 still remains valid.
Okay, next question is from Kerry Guzman Ramirez. I'm not sure if this applies, but I'm inquiring about my spouse. He's in Dominican Republic and I'm in the States. When can we expect the interview process for him to come here, or how can we get this to work? I am so confused.
Right. Remember, there's the presidential proclamation bans certain permanent residents from undertaking the interview process and entering the United States. That proclamation is deemed to sunset at the end of December. It can, however, be extended if the government deems that it wants to extend it. Now, knowing that a new administration is coming in And even if they extend it, it would only be valid for 20 days in January, because I'm pretty certain that the Biden administration would withdraw or revoke the proclamations immediately. That's what we have now. So until either if they don't extend it after the end of the month, or if they do extend it, you will see the movement on interviews after January 20th of 2021.
Okay. Next one is from an anonymous attendee. Hello, Ms. Challa. When will the significantly increased wage levels be rolled back to normal range officially? Thank you.
Right. If you're speaking about the DOL website, I thought I had read that they had already been updated. So I think DOL, and we'll probably get a post from Kara if I'm incorrect, but I believe DOL has already updated their wage levels. And okay, here she says, the DOL website is scheduled to be updated today. So it's scheduled to be updated today to reflect the previous wage levels.
All right. Next question is from Sridhar Guranti. Hello, Lakshmi Garu. I'm asking on behalf of my friend who came on H-1B visa from one of the Indian MNC company in April 2015.
Mm-hmm.
He transferred his H-1B to consulting company this year and filed his GC Perm Labor on EB3 in October 10,
Mm-hmm.
on October 10, 2020.
Okay.
He's going to complete his 6th year of US stay next year, April 17, 2021. Question, may I know how he can proceed if he has not gotten the labor approval before April 2021? Thank you.
First, see if he's got any buyback time. Buyback time is any time spent outside the United States on the H-1B, because your 6 years only applies to the periods that you spent inside the US on an H-1B. So you can buy back that time frame. If he filed October 10th, November, December, January, March, April. I mean, he's, you know, if he's got some buyback time, he may be able to at least, you know, extend his, you know, by that time his perm should be approved, and then he could file his I-140 in premium and extend it through that way. If he doesn't have any buyback time, maybe changing status to an F1. While that's pending, that could be an option, because then you can file a new H-1B petition, not subject to the cap, once the I-140 is approved. So either or leave the country and then come back in. I gave you 3.
All right. Next one is from anonymous attendee. Hello, Lakshmi Garu. Thanks a million for continued support. I'm under EB2 with July 30th, 2011 priority date, just 2.5 months away from current date. So I need your suggestion on this because my employer gave choice to me, and now I am confused and tense state.
You're not going to hurt anything by filing a new I-140 for EB3 and then filing your adjustment concurrently. Even if your EB2 advances, I don't know when it's going to advance, you can always interfile and you don't lose the benefit of that. So, you know, this way at least you're in the adjustment process. So as long as you meet the all the other issues that relate to the eligibility that we went over in the webinar, and I think Kara posted the webinar that we did on, you know, the issues that relate to filing, either downgrading, either through amendment or new petition. But I don't, you know, if you've been paid the wage, you're working for the same employer, I don't really see a major issue that you should have in filing a new petition for an EB3 and concurrently filing with your 485 now. And then if EB2 advances, you just interfile. That means you don't have to file a new I-485. You just have to let USCIS know, look, hey, I've got an I-140 for EB2 approved, and it's current right now.
All right, the next one, question from AA. I'll just say AA. It's a short form for anonymous attendee. How soon can an AOS dependent start working based on the petition for AOS? Also, can the dependent stop working on H-1B and maintain AOS status after receiving receipts for the petition? I would like to know possible options for dependents to move away from H-1B, maintain legal status, and gain ability to work based on AOS petition.
Okay. As an H-1B visa holder, you've got dual intent. So you can intend to reside in the United States temporarily. You can intend to reside in the United States permanently. So you can hold H-1B and adjustment of status at the same time. If you elect to choose one versus the other, so if your spouse is on an H-4, their H-4 is not impacted in any way by their working because it's incidental to their status, the work. It is not directly related to the immigration benefit as a derivative or beneficiary. If your spouse, on the other hand, is on an H-1B and they can work on their adjustment once they have the EAD in hand. The mere filing the adjustment of status doesn't give you a work authorized status. It's the employment authorization document, the EAD, that allows you or your spouse to work pursuant to the adjustment of status. Now, if they decide to, leverage the adjustment of status without an underlying H-1B or H-4 status, remember, if anything should happen to the adjustment, there won't be a safety net for them. I always encourage people to, they don't have to, but maintain a underlying non-immigrant status while their adjustment is pending, because I have seen situations where the USCIS makes a mistake and denies a petition. And then you can get it corrected, but it reduces the stress that you would have to go through.
All right, next one is from AA. My H-1B renewal is approved on November 16, but the H-4 and H-4 EAD still is not approved. All filed together with July 10th on receipt date. The application filed as premium processing on July 10th, but the premium receipt notice has not been sent yet, check not cashed. Is it better to cancel the check for premium at this point?
Well, they're not going to cash the check until the biometrics has been completed. So, you've got the choice of, you just want to make sure if you cancel the check that there's a notification sent to the USCIS that you withdraw your premium request for the H-4. Because that's a different service center altogether. Remember, the premium USCIS address is different from regular processing USCIS address. So the file would have to then be transferred to the other office. So you can either do that or wait for the biometrics and then they'll cash the check.
All right. Next one is from another AA. My EB2, EB3 downgrade application was received on October 12th with concurrent 48580 AP with a priority date of May 2014. After getting EAD, can I start purchase a business company and work full-time for it under the same job description?
If you have been working for remember portability comes in. So, and it's not when you get your EAD, it is the I-140 has to be approved. So if you did a downgrade, that means you filed a new I-140. The I-140 has to be approved and the 485 has to be pending for 180 days. until this takes place, just the mere fact that you have an EAD doesn't mean that you can change employers. You have to wait till the portability kicks in.
Okay. Next one is from another AA. Will my 140 downgrade be denied if my company has negative tax returns showing losses for consecutive years?
Not if they have been paying you the wage offered, whatever wage was on the certified PWD and PERM. If they've been paying you that wage or higher, then even if their tax returns show a negative, they should be able to demonstrate ability to pay.
Next one, another AA is asking HR 1044. When will this be presented in the House for vote? What are the chances of getting majority votes and becoming a law?
Right. So I talked about this earlier. It's now gone into committee, where the committee, they'll take the House bill and the Senate bill, and they try to come up with some sort of negotiation and agreement. There were a lot of unfortunate amendments that were attached to the SB 386. So as a result, some really restrictive immigration amendments that were attached. So it just depends on how long that negotiating process will take.
Next one is from AK. Please let me know if the filed I-140 downgrade approves without having paychecks from the current employer. I joined full-time few months ago, but per my request, my previous employer filed I-140 downgrade with 485. Any chances to get RFE on I-140 downgrade if I don't have paychecks?
No, the issue is why we submit paychecks for an I-140 is to demonstrate ability to pay. So if you haven't been paid by that employer, you have to demonstrate ability to pay by other means. The employer does, either through his tax returns, showing that the net income is greater than the proffered wage that's been offered to you, or the net current assets. That means the net assets minus the net liabilities is greater than the salary that is stated on the PERM application.
All right, next one is an AA. If I change employer after 6 months of 485 is applied and my prior employer revokes my application, do I lose my status?
No. I would say it was during President Obama's reign. So that would have been, I'm trying to think, 2016. In any event, President Obama issued some regulations updating when the I-140 can be preserved. And so it can be preserved even if remember the I-140's got to be approved, the 485's got to be pending for 180 days. And if that takes place and subsequently the employer withdraws or revokes the I-140 and you have same or similar employment, then your permanent residence is preserved and your ability to get extensions on that remains. So, at that point you can self-employ and you would still be okay, but it's got to be, I-140's got to be approved and 485's got to be pending for 180 days.
All right, how much time do you have?
I think it's 2 minutes.
Okay, so I've got 2 more questions here. And so we'll just conclude with that. If I did not answer your question and if you need further clarification on an answer that you received, please do send an email to info@challalaw.com. Be glad to, clarify further. So the next one is from Tuba Kadwani. How long is USCIS taking to process I-485 via Texas Visa Center, on an average being more than 22 months?
Yeah, we'll have to see, you know, anything that we talk about now is going to change in 2021 if there's additional funding, various allocations. We've got a new person who's very pro-immigration at DHS that will want to reduce these delays. So anything that I tell you now, I mean, right now it looks like it'll only be worse before it gets better, because we've had a lot of filings within the past 2 months. But that being said, I think that there are going to be some steps to address the the crazy delays that we've been having.
Before the last question, there's one question or request on the chat from AK. Please let us know by when we can have this uploaded to YouTube, since we want to recheck or re-listen some answers.
Sure.
I said,
Usually Kara gets it in, later today, and then she sends out an email to everyone letting them know it's been uploaded. Really appreciate if you find the information helpful, if you can share it with your friends. The EB2 to EB3 that she shared in chat, I've had so many people tell me that that really helped them understand the downgrade process. So if you share that and this with your friends, and comment and subscribe to our YouTube channel, would be really helpful. Thank you.
okay, last question is from Rahul. Rahul is asking, is it a good idea to upgrade to premium my H-1B that was filed with new wage in regular processing?
Don't upgrade until after January 20th, 2021.
All right, so that's about all for now. I think if we didn't get your answers, questions, please send an email to info@challa.law. AK, I just want to follow up. If the N-400 is filed in 2019, the new I-20 questions will not apply, right? Please clarify. It says if the N-400 is filed in 2019, the new I-20 questions will not apply, right? Please clarify.
Yeah, if it was filed in 2019, then whatever questions that were relevant at the time of that particular N-400 questionnaire would be relevant. Anything that's changed afterwards would not.
All right. So that's about all, guys and girls.
I mean, the new civics questions, yeah. So that won't be, the new threshold would not apply to previous applications.
Okay. I'm going to just take this one more question because it's been hanging around there, and although we said not to ask. So the AA is asking, fingerprinting for H4 was done on September 23rd. Have not encashed the check for premium processing. I cannot apply for downgrade on immediate joining the prior employer if he's showing negative returns, since no paychecks will be available.
I couldn't hear. There's some, I think, static or something from your end. So as you were speaking.
Fingerprinting for H4 was done September 23rd, and I have not encashed the check for premium processing. I cannot apply for downgrade on immediate joining the prior employer if he is showing negative returns, question mark. I guess the question is then, can I join a previous employer if he's showing negative returns, since no paychecks will be available? Right.
So I want you to look at our, in chat, they've posted the EB2 to EB3 webinar. In that, we go over ability to pay. How can you demonstrate ability to pay when you're joining an employer that you're not working for? So there's 3 ways in which you can do that. And if they can't do it, if their tax returns are negative and their, their net current assets are negative, you have to demonstrate ability to pay from the time the labor certification was filed to the I-140. Good news is, if you're not If you're downgrading and you're filing a new I-140, then you again have to demonstrate ability to pay. If you are not downgrading and you're just leveraging an old I-140, you don't have to demonstrate ability to pay at the time of the adjustment. But look at that and see if they could qualify to show ability to pay in those other instances. But it's critical that they show it one out of the 3 ways. And if you are filing a new petition because you're downgrading, it's from the time of the labor certification up till the time you file the I-140, which would be now.
Well, that's about all. And on a good note, so we all see you in a couple of weeks or 3 weeks, I guess. So happy New Year and happy holidays, and stay safe and don't party too much and be careful. And we'd like to conclude from Sridhar Goranti, who says, thank you so much, Lakshmi Garu, for responding with all the patience and helping our Indian community. Happy New Year to you all.
You're welcome. I hope everyone has a really happy, wonderful Christmas and Merry Christmas and a Happy New Year. For all of you that have been struggling with, all these immigration issues, whether it's backlogs or delays, may 2021 give you more light and reprieve. I wish nothing but the best for whether you're my client or whether you're going through the process, and for all of you. I just hope that everything gets easier and better, that your kids can benefit through your permanent residence process and the backlog gets addressed, and that there's smart immigration reforms that are put in place to address these struggles that you've been going through. 2021, I think this is going to be a good year for us. So look forward to talking to you then. Stay safe.
Marion Hinchik and Hafizullah Bhatt also are wishing everyone happy New Year, and thank you all for your good wishes.
Take care. Bye-bye. And stay connected with us, because if there are any updates, whether it's the 24th or 25th of December or the 31st, we'll be communicating through those vehicles. So stay in touch. Take care. Thanks, Shaker.